Good evening, everyone. My name is Peter Acker. I'm an immigration attorney here in Atlanta. I'm an AOL certified immigration attorney, and I'm the managing member of PH Acker & Associates. We handle all types of immigration cases. I actually even do refugee cases as well. So I do refugee, family-based, and as I'm talking about tonight, employment-based immigration. So what I'm going to speak on tonight is obtaining green cards through business opportunity and the general business routes. Business immigration. So, first thing I want you guys to remember is hello. Good, you guys got that, because that's what I'm going to be talking about for the first 15 minutes. Because the most common form of non-immigrant visas that businesses use to bring employees over here, or investors use, start with H, E, L, and O. It's not exactly H-E-L-L-O, but it's H-E-L-O. The first one, H-1Bs, are specialty occupation aliens. And what I talk about that is the general type of people that would fit in this category are lawyers, engineers, analysts, sometimes even nurses, people with a bachelor's degree or equivalent. And we're talking about a U.S. degree. And if they don't have a U.S. degree, they can satisfy that rule by what's called the 3-for-1 rule, which means the individual needs 3 years of experience for every 1 year of school. There are 65,000 visas in this category, but the tricky thing about it is that you have to file literally on April 1st of each year in order to really get the visa, because if you're 1 day late, you're probably going to get stuck in the lottery for this visa. And so you'll see on April 1st a lot of trucks backed up at the service center that processes these petitions, because everybody is trying to file literally on April 1st. The way this visa works is that a U.S. employer, a U.S. company, petitions for the foreign national, and before they even do that, they have to get what's called a labor certification, a labor condition application. And that they have to get that through the Department of Labor. But once they obtain that, they file the petition. Once the petition is approved, it gets forwarded to the consulate where the person resides, and the person goes to the consulate, applies for the visa, and then once they get the visa, then they come to the United States. One thing that I will say before I even get into the rest of them, each immigration case is unique. And sometimes individuals and companies will have multiple different routes, all of which are perfectly valid to bring a person here, or that a person is eligible to come here. But the duration of stay for the H category is 3 years plus you can get 3 years of extension. The next category is for treaty traders and investors. These are individuals not associated with a particular company in the United States, but rather these are individuals that are coming to the United States for substantial investment in the United States. However, the key attribute to this visa is that the foreign nation, the nation of the foreign national, has to have an investment or trade treaty with the United States. And so you have to look at the list of countries that have investment or trade treaties with the United States before you even consider this option. Just for a heads up for investors, for example, the United States does have treaties with Cameroon, Congo, both of them, DRC and Republic of Congo, Egypt, Ethiopia, Liberia, Morocco, Senegal, Togo, and Tunisia. And so nationals of those countries that are looking to invest in the United States can utilize the e-visa if they're coming to the United States to engage in substantial trade or substantial investment. There is no definition of what substantial is, and there is no threshold. It's a case-by-case analysis, and there are certain aspects beyond that, and one of which means that the investment must be beyond what the person normally lives off of. So they can't come and set up a company and just live off their income from that company. They must be truly coming to the United States to invest beyond that which they normally live off of. They have to also prove that the income that they're using to invest in the United States was obtained through lawful and legitimate means. And sometimes that can be an issue. You particularly see that issue with Iranian clients, sometimes DRC clients, where the funds being used may have at some point been transferred through a bank that is restricted. And in those cases, sometimes, if you're lucky, you can get an OFAC license to be able to invest that money. You also have to prove that the investment is at risk. It's not just a, hey, I'm going to put that money, and then the second I get here, I'm going to take the money out. You actually have to place that investment at risk. The investor also has to have a controlling interest in the company that he's founding in the United States. With this, there is no petition by the US company. The foreign national goes directly to the consulate and goes through the visa process directly through registration with the consulate. As I said, there's no petition required. The initial visa is valid for 5 years. However, the duration of stay is usually 2 years. However, they can get unlimited extensions. So sometimes you'll see people here on an investor visa for 15, 20 years, because each year they can just show that that money's still there, they're still investing, and they just can go renew their visa. As I'll speak about later, nothing precludes people from also, once they're here and investing, from getting an employment-based green card through their investment, or what's called adjusting status once they're here. So that's the primary non-immigrant visa used by foreign investors in the United States, with which there is a treaty between the United States and that foreign country. The next type of visa, L, H, we're all the way down to L, is executive transfer visa. This visa was created, for example, you guys realize how Volkswagen has offices in Germany and in the United States, right? Well, sometimes Volkswagen wants to transfer one of their executives between Germany and the United States. They would use this visa. This visa, you have to prove that the company petitions for the individual, but they have to show that that individual is an executive. Again, there isn't really any definition of it, but there are some standards. You have to earn like an executive, you have to have the experience and knowledge of an executive, and you have to manage projects and people. Furthermore, the executive has to be employed in the foreign arm of the US company for 1 year out of the preceding 3 years. And you also have to prove that the tie between the foreign company and the United States company. So there must be an affiliate or a parent subsidiary relationship between the two companies, even though Coca-Cola is a good example. You see Coca-Cola in the United States, you see it in Congo, you see it in Germany, England. There's a very clear affiliation between Coca-Cola Germany and Coca-Cola United States. So that would be a perfect example of if Coca-Cola wanted to transfer its executives or a concept, an individual with a concept in Germany here, they could use an L visa. The L visa is preferable to a lot of people because it's got a 3-year initial duration of stay, and you can extend it for up to 4 years. And the key about that is that gives the individual perfectly enough time to apply for and get their green card. So a lot of times the way companies do that is they'll transfer an executive here, and if they like him and they want to keep him here, then they'll just apply for his green card through one of the categories that I'm going to be talking about here in a minute. However, if you don't apply for adjustment of status of your green card, then if you've maxed out all the time period, which would be 7 years for an executive, you have to go back to your country for at least 1 year before you can come back again. So that's a little bit about L's. What you need to think of in your mind is executive transfers, transferring managers and executives between companies. The final non-immigrant visa category that I'm going to be talking about, and these are just the common visa categories. There are numerous visa categories. These are just the basic common business-based visa categories. But the last one is what's called extraordinary ability aliens. And these are people who are foreign nationals of extraordinary ability in the sciences, the arts, education, business, athletics, movies, and television. Again, what you have to prove is that the person is extraordinary. And you have to do that by showing that they're a person of sustained national or international acclaim. And in order to prove that, you can show that they have received a national or international prize of excellence. They've been published in major publications. They've been a judge of the work of others. They've made original contributions to their field. They've authored scholarly articles. They've been employed in organizations of international acclaim and reputation, and that they've earned a very high pay for their unique and extraordinary abilities. Like the L, as I'll talk about in a minute, the O category, extraordinary ability aliens, sets one up to apply for a green card. The initial duration of stay is 3 years, but you can get unlimited extensions on that visa. And usually what you see is if you have a person of extraordinary ability, let's say they're one of the top 3 recognized sound engineers in the world. They'll come to the United States for 3 years, and then they'll apply for a green card based on their extraordinary talent in that field. But they have to prove that they are, one of the top in their field worldwide. And as you'll see in the green card based off of this, what USCIS publishes in their regulation is, as an example, is a Nobel Peace Prize winner. Well, there are not a whole lot of Nobel Peace Prize winners. And not a whole lot of Nobel Prize winners in general. But fortunately, that's not the sole standard. You can use multiple different criteria that I mentioned. For example, so you go back. Receipt of international prizes, membership in elite associations, things like that. If you have multiple of those in your resume, then you might be able to meet that category. Which leads us to our green cards, from which you can, off of these non-immigrant visas, adjust status into a green card. The first category is the employment-based first preference category. Everybody loves this category, but it's really hard to get. Everybody loves it because all the visa bulletin is current across the board. There is no wait time. It's basically just a processing time for the green card, as long as you prove that you fall within this class. The first part of the EB-1 is the same criteria as the executive transfer visa. So basically, if you can prove that you are an executive or a multinational manager, then you can, once you come here, you can apply for a green card through EB first preference category, and there is no wait time. You can get your green card. Likewise, if you've come here on an O, then you've probably already fulfilled the requirements for extraordinary ability, and you can probably petition for an employment-based first preference category based on your extraordinary ability. However, those are really for multinational executives and really the elite of elite in what they do. However, that elite status can be of national or international acclaim. So if you can prove that you're the best in your country at that particular thing, then you might be eligible to do that. However, what you see a lot of people do is under the employment-based second preference category. And that's where you'll see a lot of the investors, a lot of the first H non-immigrants will go through the second-based preference category. And that is exceptional ability or advanced degree foreign nationals. Basically, you have to have a degree beyond a bachelor's degree or its equivalency. But the process takes a while longer because you have to get what's called a labor certification, otherwise referred to as perm and recruitment process. And that can take some time. But the category is also current. It just takes some time to get the paperwork set up so that you can file. So there are exceptions to, and for this category, for the second preference, generally speaking, you have to have a U.S. company that is willing to petition for you. So usually what you see in this kind of scenario is, let's say you have an analyst, and you bring him here on an H-1B, and while he's here, you apply for the employment-based second preference category, you go through your labor certification process, and then the company petitions for him, goes through the labor certification process, and then if he gets the visa, then he's a green card holder. Right? However, this category is current, but history has shown that it's not always current. Sometimes the visa allotment for this category backlogs, and occasionally there are wait times. However, currently it's correct. Just a short note, there is actually an EB-3, which is for professionals or less than exceptional ability aliens. However, I'm not going to delve into that because the current wait time is 6 years. So it'll take about 6 years before you can, before you're eligible to adjust status or get your green card through that category. And which brings us to our last category, which the Chamber was very interested in, and most people are very interested in until they realize one key attribute, and that is the EB-5 Investor Program. Basically, here's a saying, well, you can buy a visa, right? Well, this is kind of that category. If you have $1 million, if you're a high net worth individual and you have $1 million, you can buy a green card. As long as you show that you're investing that $1 million in the United States, that you're creating 10 US jobs, and that and you can show that all of that money was obtained through lawful and legitimate means. And here comes the last part that people are very uncomfortable with. That money must be placed at risk. So basically the individual has to deposit it in a company which they do not have sole control of. There cannot be buyback provisions, there cannot be parachutes. That money, once it's invested, it's out of that person's control. Now they can certainly, if the company that they're investing that $1 million in does well, or if what they're investing the money in does well, then they can certainly earn money off of that. But if the investment goes bad, they can't have an agreement whereby, oh, that company or that investment immediately has to pay me back the money. Otherwise, they're not eligible for the visa. So, however, if you invest in what's called TEAs, which is targeted unemployment areas or regional centers, that lowers the threshold to 500,000, and the job creation requirement, you only have to show that 10 jobs were indirectly created. You don't have to show that I'm directly creating 10 US jobs in a company. You can say, oh, well, 10 jobs were created indirectly from my investment. And the reason they set up this program is what's called the TEA, the Target Employment Area. That area can only get designated as such if they can prove that it's an area that's a rural area, an area of high unemployment, or an economically depressed area. So basically, the investor has to be investing in a program that is an area of high unemployment or has economic depression, but that lowers the threshold that they have to place at risk. That lowers the threshold from 1 million to 500,000. So, but that's the general overview of business immigration in any individual case. As folks and Tony and Robert found out, each case is unique. A lot of times businessmen and investors have multiple different routes, all of which are perfectly valid routes to obtain a visa. And in addition to your employment and your business-based visas, if you have a family-based immigration situation, then it may be more cost-effective to adjust through that. So in any individual case, when I sit down with a client, it takes about an hour to an hour and a half to go through a full interview because I need to review that individual's entire life. Where are they from? What country are they from? What is their educational level? What is their net worth? Do they have U.S. citizen relatives? What is their business concept? What do they want to do? Because the answer to those questions can cause my answer or my presentation of options to that individual to be completely different. So, and a lot of times, as you see, businesses have a high net worth individual like a CEO or an entrepreneur that has earned some money will have multiple different ways of obtaining a green card or obtaining a non-immigrant visa, which would lead to a green card. So, that's a basic overview in a nutshell in a few minutes of employment-based immigration, and I'll open it up to the floor.
Good.
Okay, if a company applies for a green card on behalf of an executive, from the time that they've done their biometrics, what is the turnaround time to get to that appointment?
by the time they've done the biometrics.
Yeah.
The biometrics actually usually occur at a relatively late stage. That's once the petition has already been filed and it's currently under review. So in that case, it usually takes only about between 6 months and a year. More on the at the biometric stage, usually around 6 months or less.
Biometrics has been done already. What's the turnaround from there?
Here's something I can tell you about immigration. I get asked this question all the time. There is no timelines. However, generally speaking, a time frame after their biometrics have been taken, after the petition's been filed, it's currently under review, as long as there aren't RFEs, probably around 4 months, 3 or 4 months. So, but it could be 6 months, depending on the case. And if you're talking about first preference category, they review those cases with strict scrutiny. You have to very much establish that that individual is a multinational executive or is an extraordinary ability. So, is it?
Yeah.
Okay. Any other questions?
Which of the programs or the windows is best for business people that do not want to be getting the non-immigrant visa? They want to have something, they don't want to stay here for long, but they still want to have a green card, and they will still pay the tax. Which one would suit a businessman or a business person or a businesswoman perfectly?
Go in and out.
Oh, saying go in and out?
Yeah, going out.
It depends. It really depends on the individual's circumstances. For example, I can tell you that not too far back, I got contacted by a couple of German investors. One was a former CEO of a major European company, and his partner was a technical expert. And they had heard about the EB-5 program, and they immediately came to me and said, we want to do EB-5. And so I sat down with them, and after 3 conferences of going over what they want to do, what their business plan is, what they really want to do with their life and the kind of freedom they want to choose, it became very clear to them that actually the e-process and adjustment was going to allow for a lot more flexibility and a lot less risk than the EB-5. So it really just depends on the individual's unique circumstances. If they don't want a green card, if they don't want to be categorized as a resident for tax purposes, an E might not be a bad idea because it's got a duration stay of 2 years, but you can extend it, into infinity. An O, if they meet that if they meet that criteria, if they're extraordinary ability alien, is not a bad option because it also has unlimited extensions. But a lot of these visas, given the nature of these, will allow the individual to go and come back. I know, for example, we handled an L case for a German attorney who's a senior partner, and he flies between Atlanta and Munich probably 3 times a month. Okay. So, and he has no intention of getting the green card. He wants that freedom, and he doesn't want to be categorized as a U.S. resident. But he will run into an issue at some point when he's maxed out his max duration of stay. He's going to have to go back for 1 year if he doesn't want to go the route of adjusting status. So.
Yeah, I have a question.
As a business, like interchangeable, say if you're already if I'm in the process, you're already a resident person, and you probably want to do a business person, you want to come in and out at the interchangeable,
If they're a lawful permanent resident, if they're a green card holder?
Yeah.
All right. So the restrictions, it depends on whether they're a conditional resident or an LPR. Sorry, a green card holder. LPR is interchangeable. Lawful permanent resident is a green card holder. So if they're a conditional resident, then they have, after 2 years, such as, for example, in the EB-5 program, they're not granted full permanent residence. They're only granted conditional residence. And after 2 years, they have to go back and remove the conditions on that residency. With LPR status, green card status, generally speaking, you cannot be outside the United States for more than a year at a time, or they will revoke your green card. Also, if you're thinking about moving towards citizenship, because after 5 years, absent other circumstances, after 5 years, green card holders are eligible to apply for citizenship. If you've taken trips of 6 months or longer, that can affect your your required time for citizenship.